us as well this morning. And I'll give her just a moment to say good morning while I take a swig of coffee. Claire?
Hi, everyone. I'm Claire Parsons. I've been at a few prior sessions with Laura Anthony, if you've been to those. So I am new to Bricker Grade, and I've only been here a few weeks. I think I'm going on a month now. But I've been doing education in Kentucky and Ohio for about 15 years, in particular, a whole lot of special ed. And I come from a lot of litigation experience with due process hearings. So I'll be talking about procedural safeguards after you go over records with Melissa, but I'll be trying to help out with any questions in the chat while Melissa is talking to see if we can address those efficiently, but glad to be here.
Thanks, Claire. All right, so without further ado, let's get started. I'm going to spend some time talking about education records and how they intersect with special ed. So a lot of what I'm doing here is not special ed related. It is a FERPA and Ohio student records kind of review, but I will be pointing out where there are special rules that come out of our operating standards related to records for students with disabilities. And it's always a good overview because we know that when we are looking at procedural safeguards for students, we are very often talking about records and the creation of records and the access to records. So what protects education records? There are essentially two bodies of law, the state and the federal. So let's talk first about general education records. So we all know that FERPA is going to cover all education records, and we have a Ohio corollary to FERPA. It's actually a little broader than FERPA, but it also protects student records. And you'll see a citation to that in your materials. That's in Ohio Revised Code 3319-321. And so sometimes the answer can be found in FERPA, almost always, but sometimes there's a little state nuance to education records that we have to keep in mind. And then when we're talking about special education records, we again have some additional protections. So under the IDEA, we have some records provisions that are separate and distinct from FERPA. They are not different. They're, I'd call them enhancements that are just a little special rule there. And we have a similar corollary to confidentiality and records in Ohio's administrative code, the OAC provision, or as we call them, shorthand, our operating standards. And so again, when you think about that, there are multiple sources of law that may protect, the things that we are working with in special ed for students' education records. So you'll see on the next slide, what do all these laws do? They are basically a prohibition against disclosure. They control when we disclose either the records or information from the records. So generally, all of these laws say we cannot disclose information without the written consent of the parent or the eligible student if the student's over 18. So that's your global, rule there. So what exactly is a disclosure? A disclosure is defined as access to the release, transfer, or communication of PII, personally identifiable information. So a disclosure is more than just handing a record. As you can see, it's the disclosure of information. So it can happen in inadvertent ways. For example, let's say that a teacher walks into a teacher's lounge and starts to vent about a particularly challenging event with a student. That could be the release or the disclosure of personally identifiable information to people who are not the student's teacher. When my children were younger, I remember I volunteered in their elementary school and very often got to do things that lawyers don't get to do, like, cut out shapes and laminate them, and, and it was a nice break from, lawyering. But I can remember using the copy machine and walking up to the copy machine and finding a copy of an IEP. again, inadvertent disclosure, but I had no legitimate reason to be looking at the IEP. And so just, that a disclosure is just what it sounds like, right? But it's not as obvious sometimes as, taking a record out of a file and handing it to someone who does not have a legitimate educational interest in knowing that. So let's talk about what is an education record. What exactly are we talking about? So there's a definition, and it's broad. And when you really look at the definition, I get questions about this, fairly frequently. I always come back to this particular definition. So if you have the materials and you are a visual person, this is one of those places that you start. So an education record is anything that is directly related to the student and maintained by the educational agency. So as you start to think about it, we maintain things in files, but we also maintain things on servers. And so you start to think about all the things that we maintain that directly reference a student. We have a lot of education records. So things that it does not include, sometimes that's easier because it's not as broad. So what doesn't it include? It doesn't include your personal notes. So if you are taking personal notes, and you keep them in your sole possession as a memory aid for you, you're not sharing them with anyone. They're not revealed to anyone except maybe counsel. That does not just take the nature of a personal note away if you share that with legal counsel. But if these are truly your personal notes, that is not an education record. Employee records, they are not education records. Think about the definition again. More than likely, your performance evaluations do not directly reference a student. They're certainly maintained by the school district, but they don't usually directly reference a student. And so those are not education records. Of course, those are subject to the Public Records Act. Someone can come and request a personnel file under the Ohio Public Records Act. So not an education record, though. Law enforcement records, unless the law enforcement entity is actually employed by the school district. But generally, your SRO records, those are records that are maintained by law enforcement, and that law enforcement is typically not an employee of the board. They are an employee of the local sheriff or the local police department. Unless they have been defined in an annual notice, we'll talk a little bit about that later, for FERPA as a school official, we find that typically the law enforcement records are not education records. So if a parent wants to see what an SRO has, they need to go through the police department, not through us, right? There was a long litigated case, very interesting case. It's quite old now at this point, about teachers that would give a pop quiz and then tell students, hey, exchange your pop quiz with a peer across the aisle or at your table, and let's grade one another's tests or quizzes, and then maybe call out what the student's grade was. So 4 out of 5, 5 out of 5. And there was a question on, does that count as the disclosure of personally identifiable information about a student to others who do not have a legitimate educational interest? Now, I don't think there are many teachers that call out the grades, but the question was raised and it went all the way to the Supreme Court. And we do have an exception that peer-on-peer graded papers before they are collected and recorded by a teacher do not count as educational records. So just in case you need that case, it is there. It is available to you to tell you that that is not an education record. Now, of course, once it's collected and recorded, we have created a record, an education record. Treatment records, if you have programs, again, that are operated by the district, and they are used in treatment of a student, psychotherapy notes. It does not include remedial educational activities. There are some special rules around actual mental health treatment records. If you are facing that question, we would suggest that you work with legal counsel on that, because there are some nuances there. Attorney-client privilege communications. So when you email, even on your district email, your district counsel about a student, that there's an exception. That is not an education record as well. So, as I said, when we looked at the definition together, this is very broad. And so we get beyond the idea of a paper copy of something being a record really quickly. Records in the definition it clearly says it goes beyond paper records. It includes print, emails, computer media, videotape, audio tape, film, microfilm, and microfiche, if anyone's still using those. And so all of those mediums that we maintain can contain education records. And there's one I want to talk about in particular. And the reason that I want to do that is because we've got some very specific guidance on it. And I'd have to say it's an FAQ. So on the next slide, you will see a letter that came out in 2017. And it dealt with the disclosure of video, particularly surveillance video of two students in a fight. And for many, many, many districts, this is probably the most common education record you get. There seems to be this notion that if there's a video, we don't disclose that. Well, go back to the definition of education record. Does it directly reference a student, a video of a fight in a hallway between two kids that the administration reviews in order to decide that they are going to administer discipline? Yeah, it does relate to that student, right? So it does directly reference the student, at least the students in the fight. And if we are recording it and it's on our servers, we are maintaining it. So it is an education record. And that's essentially where this letter to Watcher starts in analyzing this. But there's a bunch of questions that are answered in this letter. Many people have said, well, but there's, 30 other students on the video and, is it an education record for all of them? This letter actually tells us no, it's not. And this is a Bondi term, not a federal government term, but those other students who are not involved in the fight, maybe they're just observers or bystanders, or they're walking in the hall, or they're moving out of the way because they're making room for the fight. They're window dressing. They are not the subject of the video. And so it's not an education record about those students, but the students that we're administering discipline for, it is an education record for them. The letter goes on to say that if you have the technology to fade out or gray out all those window dressing students or individuals, then go ahead. Certainly, let's protect their identity. But if the district can't easily do that, then that's okay. The parents of the students involved would still get access to the video. And so that's what this letter talks about. And most of that is summarized in your materials. You will see it's very clear. Parents have a right to see that video. Now, as a practical matter, what I think our offices always tell school districts is you don't want to create a copy and release it to the parents. Very often when we think about providing parents access to records, the knee-jerk reaction is to copy and give it to them. But FERPA is a statute of access. Parents have the right to access education records. And that means we don't necessarily have to provide a copy unless not providing the copy would somehow infringe on the right of access. So if you have a parent that lives in another state, right, we might need to copy that and make that available for them. But as a practical matter, what we often do is say to school districts, bring the parents in, allow them to view the video, but do not give them a copy of the video, because fight videos have a tendency to find their way onto social media and everyone has an opinion, and you want to control the access to that. And so we will invite parents in to view that. So I'm going to peek down here because I see a couple of things in the chat. I'm assuming nobody has a question about that. That was one of those areas that I think we tend to get some questions, but does not look like we did. So, all right. I want to say a quick word before we move to what qualifies as personally identifiable information about testing protocols, because that's one other area that we get a lot of sticky questions about. What about testing protocols? Are those education records? So the Family Policy Compliance Office has issued opinions that say they are education records, but only if they directly reference a student. So sometimes those booklets for an assessment, of course, are just that. They're just booklets with questions, and there's an answer key. The answer key, if it has the student's name, would be an education record. If the two cannot be separated and the assessment booklet has the student's name, it is an education record. And so you have to look at whether or not it contains personally identifiable information. Parents have the right to receive explanations about that. And again, because we worry about the integrity of the assessments, or maybe even the copyright protections on those assessments, it's a right of access. And so as a practical matter, we often will advise school districts that parents can have their psychologist, treating professional, have access to review assessment booklets or protocols, but we do not copy them for them and make them available. So there are ways to work through that as well. But there's some information in your materials about testing protocols and assessments. All right. So as is identified on the screen, the next thing we're going to talk about is what qualifies as personally identifiable information, because that's what's protected in an education record. And it is almost everything. It's a student's name, the name of the student's parents, the address, the social security numbers, identification numbers. One of my favorites, biometric records. And as we get more fancy in the world, I, for example, know that my kids can pay for their lunch by putting their thumbprint on a screen, and it scans their thumbprint, and then their account is charged. That scan of their thumb is a biometric record. You can see that we might get to the point where we have schools that have retina scans to get into, right? And so those kinds of things, of course, are going to count as personally identifiable information. Student's date of birth, other information. This is what I call the collect the dot rule. Other information that alone or in combination with other information can be linked to a specific student. And this comes into, this particular piece comes into play. Let's say I have that fight, right? And very frequently we will have administrators who take written statements from multiple students. And then we have someone who asks for all the records related, all the education records related to their students in discipline, and all of those witness statements then become, we have to ask, does it directly reference the student? Probably, right? Because they're talking about the fight their kid was in, and is it being maintained by the district? So that's an education record they would have access to. But it also has personally identifiable information about other students, other witnesses, the witness themselves. And the question becomes, what do we do with that? So frequently people will take a, Sharpie and block out the names. And I always say, make a copy, because we've learned that you can read through blackout on a copy and sometimes still make out what's under that. So make another copy there. But after that, they release it. And this is the connect the dot exception. Other information that may be out there may allow the person who receives the record to still identify what name or what personally identifiable information has been blacked out. If the requester can still connect the dots and know what you blacked out, then there's a very good chance that we couldn't release that whole record. And so again, when you get into those situations, you may want to work with counsel, but that's the connect the dot piece of information that's still personally identifiable information, that when you can link it. So I think I did have a question. I thought I saw it pop up on the screen and then disappear. Yes? I did. Uh,
Yes.
Going back to protocols, how long do we keep testing protocols and where do we store them? It's a really good question, and it's not driven by FERPA. Every school district has what is called at least in Ohio, a records retention schedule. And it is maintained by your treasurer. It is approved by the Ohio Historical Society, and that records retention schedule tells you how long you keep certain records, including assessment records, which would include protocols. And so that's going to be controlled by the records retention schedule. As for where you keep them, that's a local decision, but I obviously frequently, if we're talking about special education records, ETRs, those kinds of assessments, those would be kept with your special ed records. I do know districts that keep them in, in a counselor or psychologist's office. So again, I think that's more of a local decision, but the retention of how long is going to be controlled by the records retention schedule. So good question. All right. So then let's move to when can we disclose? Who can access and when can we disclose all of this PII, that's short for personally identifiable information, that we're in charge of protecting? So generally, the number one way that education records are accessed is by the parents. Parents have the ability, including the non-custodial parent. So very frequent question. Okay, I have two parents, they're involved in a divorce. This child lives with mom. Dad wants to access the education records. Can he? Yes, because FERPA has a very broad definition of who is a parent. It is, unless there is a court order that has changed the rights of the parent, then it's the biological parent. So even the non-custodial, non-residential parent under FERPA can access their students' education records as long as they're the bio parent, right? And so that is the first of who can access. There is an exception. If you have been presented with evidence that there is a protective order, particularly in a domestic violence situation, there is an exception to that bio parent being able to access records. Obviously, if we have one parent and child, seeking safety, let's say in a domestic violence shelter, and their address changes, we're not going to turn around and disclose that to the person that they are seeking protection from. So there is that exception. But again, that would come from a court. So unless a court order has changed the access, bio parents have access. The next person who has access is the student themselves if they're over the age of 18. So we call those eligible students. Or, and here's for all of you that have students that are getting up there in years like me, as they approach 18, you can start thinking about this. When they turn 18, all of their rights under FERPA, all of the rights under FERPA transfer to the adult student. They also transfer when a student engages in post-secondary education. So the College Credit Plus records, any college classes that they're taking, for high school credit, those are also records where the student would control the access to them. So you can start to see, as you out there, some of you out there may be parents with older children, you can start to see why it is that your child might go off to college. You're paying the tuition bill, but you don't see the grades. If the student does not give you consent to access their records as an adult, as an eligible student under FERPA, you won't see them. And so that's one of those conversations I'm going to preview for you. You may want to have with your seniors and college freshmen if that's important to you. Who else can access? School officials. And school officials are defined both within board policy. They are defined in an annual notice that goes out every year in those forms that parents get at the beginning of the year. We give them notice of their FERPA rights and who the district has defined as school officials. But they are typically someone employed by the district who has a legitimate, and I'll use this phrase a lot, a legitimate educational interest in that information. So members of a student's IEP team, right? If even if they didn't sit in the IEP meeting, they of course have access to the IEP. Why? Because they have a legitimate educational interest in that record and in implementing that record, right? And those services that that record provides. So those individuals who have a legitimate educational interest. Your annual notice will often define people like contractors. So if your district contracts with the ESC for OT, PT, SLP services, those contractors immediately have access to those records, even if they're employed by the ESC and not the district, right? Because they are your contractors. It includes your board council. And so you have to work through who is or can be considered an individual with a legitimate educational interest in the record. I think I saw a question pop up. Yes, I didn't read it yet. Let me take a gander at this question. So if we have students who are 18 during their senior year, but are not attending, I think we mean school, do we involve the parents? It seems like we should, but it sounds like the student will make the decision if they attend or not. Yeah. If we don't have, I'm assuming, because the question doesn't tell me, that I'm talking about a kid with a disability, because there's a special rule for kids with disabilities on certain things. But if we are just talking a general education student who has turned 18, yep, they have the ability, if there's not been a guardianship established over them, declaring them, let's say, mentally incompetent, they have the ability to drop out, yes. And they have the ability to control who sees their records. Check your board policy, because sometimes we've written things in there for it, but generally, again, if no one has declared the student incompetent, they are an adult, they control the access, and they are no longer of compulsory school age either. So if you have a student who is 18, who is a student with a disability, there's a special rule about when you provide certain records to parents under both the IDEA and the operating standards. Anytime you have an adult student with a disability and you are providing a procedural safeguard, such as the prior written notice, the rule says those go to both the eligible student and the parent. It's very paternalistic, and it's an exception to the general rule. But the idea is that the parent could, of course, intervene on behalf of their 18-year-old student with a disability. So there is a special rule there that doesn't exist for gen ed kids. All right. So let's move on. Other individuals who might be able to access records, those individuals with consent. So anytime the parent has provided us written consent, signed that release of information document, those are individuals who can access the records. Those releases should talk about what records can be accessed, the purpose, so for assisting in making educational determinations. You frequently see these for doctors, treating health professionals, and of course lawyers, when the parents have engaged another lawyer. And those are usually time sensitive, so they'll be good for a year. So you take a look at those when you get them, but those are the only individuals that can access, right? Parents, eligible students, school officials, and people for whom there's been consent. And then, as suggested by this screen, FERPA has a ton of exceptions. We will not cover all of the exceptions that FERPA has, but I am going to talk about some of the most common exceptions that we have. So the first one I want to talk about is directory information. Remember, I referenced that annual notice that goes out in your, let's say, final forms at the beginning of the year to parents and students and tells them about their rights under FERPA. One of the things it tells them, I told you, was who do we consider a school official so that I can disclose records to these people without your, without having to get your consent. One of the other things it does is it says, this is information, and it'll have a paragraph that the district has identified as directory information. And directory information can be disclosed without your consent, and the district gets to define that. So it can include things like the student's name and address. It can include their place of birth, their enrollment dates. Participation in school activities is usually the big one, so that when the school paper comes and has the team photo and they want to publish it, or the local paper comes and wants to publish it, the district can release that team photo and the names of the students, even what they play, maybe, depending on how they've defined that information. It never includes students' social security number or their I was going to say ODE, but we're now calling it DEW here in Ohio. Dues, identification number, those kinds of things are obviously never going to be part of directory information, but it can be different. Some districts have not defined photographs as directory information, and so you'll take a look at those sometimes to see what is directory information. Parents can opt out. They can say, I do not want you to I do not want you to release directory information to anyone. And they have that ability to do that in the annual notice, once they receive the annual notice. So for example, you may not disclose my student's name, address to the paper. Okay, those types of opt-outs apply for more than just the local paper. So for example, after 9/11, we saw that there was a military recruiting effort. And so we had a lot of parents who opted out because they didn't want information to be disclosed to military recruiters about their student for recruiting purposes. And that's fine, but you can't opt out for some and not other reasons. So if you opt out of the disclosure of directory information, you also opt out to any colleges that are recruiting, anyone who's, wants to sell a class ring. And so there is no, well, you can disclose to some, but not others. It's a blanket, one or the other. And so that does exist there when the parent opts out. Another exception, I think I saw a note from Claire. So let me take a peek at, we may have a question. So let me see. And my screen on my question is frozen. I think I answered
Melissa, it was a question about whether someone could be a parent if they are the father residing with the child, but not actually having been established via a paternity proceeding in court. And I said that the definition is broad enough to include a situation like that, but you probably want to understand more facts, including whether there's any relevant orders, and consider that with your board attorney.
Yep, I agree. And there are lots of nuances to that when you get to that. And that's specific to state law that I usually kick over to one of our probate attorneys. So excellent idea to consult with counsel, because each of those has a little bit of a different nuance. So thank you, Claire. Going back to qualifying exceptions. So we talked about the first one, directory information, and all the information about that, how parents can opt in or out. The next one is the health or safety emergency. And this was a newer exception. It went in when FERPA was reauthorized. I should say it was expanded. And it was a direct response to the Virginia Tech shootings in 2007. I can remember it was 2007 because when I had my son, you buy the newspaper on the day they were born, and that was the day he was born. And as a result of that particular shooting in April 2007, FERPA was modified. And we talked about what we could disclose to law enforcement officials when there was an emergency on our campus, because one of the findings that came out of that was that the college, Virginia Tech, had felt that its hands were tied in releasing information to law enforcement about our shooter in that case. And so there are some very specific requirements in order to be able to disclose personally identifiable information without consent under this exception. You've got to be facing an immediate, articulable, significant threat. And the regs talk about looking at the totality of the circumstances. So obviously, a school shooting is going to be one of those. And so that is one of the qualifying exceptions that we have, health and safety emergencies. The student's new school is another exception. So when the student seeks to withdraw from you and enroll somewhere else, we are permitted to release information to the school where the student seeks to enroll. They don't even need to be withdrawn in order for us to do so. If they've done an application and they're still our student, obviously, again, that enrolling school is entitled to particular information about the student. It has to be information that is related to the student's enrollment or transfer. So we're not going to release, every single piece of information, but what is relevant to the enrolling school. Now, under our operating standards, so specific to students with disabilities, this is one of those places where, again, we have a special rule. So under our operating standards, the previous district in Ohio must send the student's current IEP and any statement of current or previous disciplinary action that has been taken against the student. We're not going to sandbag a district with a not disclosing information about disciplinary events with a student with a disability. And so we can release that information without parental consent. Now, the operating standards, as you all know, were reauthorized in July, I believe, of 2023. It may have been June. Don't quote me on it. Why don't we just say in the summer of 2023? And now we have a new rule in the operating standards that says that a statement regarding any disciplinary action may, so it's not a must, include a description of other behavior engaged in that required disciplinary action and a description of the disciplinary action taken. However, this information may only be transmitted to the extent permitted by FERPA, even if we're sending the information to the enrolling school district. So we can now include a statement, a little bit more broad, of past behavior. So we have a student that's engaged in a pattern of behavior that maybe has led to the discipline, that has the student seeking to enroll somewhere else. We, again, can disclose information, a statement about that disciplinary action that has describes behaviors that have previously been engaged in. Another exception that we have is government officials. So do we, do we have to disclose to ODE and the Ohio Department of Education when we are responding to complaints? Absolutely. And we can release information to those governmental agencies. One question that we often get is, what about law enforcement? Does that count as another governmental agency? Well, FERPA does not consider law enforcement a school official unless we have defined the SRO as a school official in our annual notice. And so I think very frequently you will find that districts exchange information, personally identifiable information, with their SRO quite freely. But you have to be careful, because unless we're under a health or safety exception or there's consent, they are not a school. They're generally not a school official. There are some exceptions about that come from our operating standards and IDEA with our students with disabilities. For example, the IDEA does permit us to report crimes committed by children with disabilities, so maybe an assault, to appropriate law enforcement. But in doing so, there's a nifty little exception that, or piece of information that lots of school districts miss. When we do so, the school is required to send copies of the student's special education and disciplinary records for consideration by law enforcement. So they're supposed to consider that they're working with a student with a disability. The only way to do that is with consent. And so that's a very difficult exception to satisfy. Um, Now, there are some crimes that we are required to report, and those are felonies, of course. And so that and firearms, we are required to report those to law enforcement, and so those could be reported without consent. The other time that we can disclose to law enforcement is in a children's services investigation. They have the ability to run those investigations, often without us even letting the parent know that we've been involved. And if we are the reporting entity, very frequently we are reporting personally identifiable information. So there is an exception for that. There is an exception for armed forces recruiters. We have talked about that. Typically, that comes into play when a parent has opted out of the information, but a military recruiter, of course, can get information about a student. And there's some others listed in your materials, but the last two I want to talk about are any records that have been de-identified. We touched on those. That's where we have a record that we are disclosing where we have redacted information from other about that student. We may be able to disclose those. I've learned the hard way that, and I'm going to mention it again because it's happened to me more than once and it was not fun, that when you do the redaction, hopefully you're either using software that does that, which completely blocks out the name, or if you're doing it the old-fashioned way with a Sharpie pen, you're making a copy of your redacted page, because it is possible to read through that black ink. So last one I want to talk about are courts and the power of subpoena. We will disclose personally identifiable information when a court has ordered us to do so, and that is through a validly issued subpoena. Always work with legal counsel when you get one of those, but if the subpoena is validly issued, that means that it can be enforced by a court. I always tell clients, let's not defy court orders. That's not usually going to work out well for us, but there are some special rules about how we respond to subpoenas. So when we get a validly issued subpoena, FERPA has a requirement that we then write the parent or eligible student and tell them that their records have been subpoenaed. One exception to that is a grand jury subpoena will very frequently, but not always, have information that says you may not disclose to anyone you've received this subpoena. So if your subpoena has special language like that, we obviously wouldn't do that. But generally what we do is we write the parent or eligible student a letter and we say, hi, we got this subpoena, there's a copy enclosed, we have to release your education records, as you can see. We are telling you this so that if you want to take action to stop this, you can. We're essentially saying if you want to go file what's called a motion to quash, then please go do so. And it usually closes with something like, if we do not receive any further information from you about preventing our disclosure, we will be disclosing the education records by the date on the subpoena. So there's a notice to the parent or eligible student that their records have been subpoenaed, and we do have to make that disclosure beforehand. Exception to that is when the district is defending in litigation cases against itself. So if the parent has sued the district and the district is defending, we do not have to do that particular disclosure in advance. So I told you there were a lot of exceptions, and that's not even all of them. But those are some of the qualifying exceptions on when we can disclose personally identifiable information from a student. So let's talk now about redisclosure restrictions. So let's say you are disclosing some information to someone for some reason. Maybe it is pursuant to a record release, or maybe it is due to a subpoena. We do have an obligation to tell the individuals to whom we are disclosing that these records are confidential, and ask them not to disclose the information to additional parties. We can't, of course, are not responsible for enforcing that, but we do have that redisclosure obligation to tell them. One of the other things we have to do when we disclose is we are supposed to keep a log. So anytime someone accesses education records, we are supposed to be keeping a log of the date, who is requesting the record, what records, and what reason we gave it to them. Were they a person with a legitimate educational interest? So I can see people out there panicking, thinking, oh my gosh, every time someone has opened the CUME file of a kid, I have not done this. I don't have this record. I've never seen a record access log. That's because, again, there are a ton of exceptions to this rule. So while you are required to keep access logs, you are not required to keep them for, and there's a list of them on page 12 in your written materials, when parents access the logs. Okay. When school officials, so somebody opened the CUME file who had a legitimate educational interest in doing so, we don't have to write that down. Parties who have consent, so the lawyer to whom we gave the records, we don't have to write that one down either. A party seeking directory information. So this is one of those rules where it's there, I mention it to you, but there are so many exceptions, you start to think, well, who would you write down on the access log once you take out the parents, school officials, people with consent, etc. But it is a requirement of FERPA. There is a very interesting exception, which I always mention just because it's different and I think little known, but a party seeking or receiving records in certain law enforcement proceedings if the court orders that the existence of that remain confidential. What does that mean? Well, that is something that was added to FERPA after 9/11. When the federal government wanted to be able to access records, and they were seeking information about people who might be domestic terrorists or children of domestic terrorists. And that particular exception was part of the Patriot Act. And so I put it there just because I've never seen it used, but I thought it was really fascinating. It felt very spy-like to me. I think that's all on the re-disclosure that I was going to chat with you about. You guys have gotten really quiet on me. So let's talk about the rights of that are available to parents under FERPA. So actually, I'm going to go 2 slides ahead here. Right here. Yep. So we know that the parents have the all-important power to control access. They can give consent to who can and can't access their students' records, but they have a number of other rights, and all of these rights that I talk about belonging to a parent also belong to that eligible student when they turn 18. So the first one is notice. We have to give an annual notice to parents that they have the right to inspect records. They have the right to review records. They have the right to seek amendment of their records. They have the right to disclose or to consent to disclosure. And if we do any of this wrong, they have the right to file a cause of action with the Family Policy Compliance Office. Right now, everyone's going, what's that? Well, so that's the office that enforces FERPA violations. And I'm going to give you one piece of good news here. That is an office that will run an investigation. It's an administrative investigation, and they may issue corrective action. But beyond that, that is the end of the enforcement under FERPA. There is no private cause of action under FERPA for parents to, let's say, march into federal court and sue you for $1 million for a FERPA violation. And so really that Family Compliance Policy Compliance Office, Family Policy Compliance Office is really where the enforcement piece comes and ends under FERPA. So let's talk about the I think I've covered most of this that I was gonna under annual notice, as we've already talked about. So I'm going to move to inspection of records, which of course is one of those rights. In addition to inspecting the records on their own, parents are allowed to have a representative inspect their records. And so typically what I will say to school districts is when you get a request for someone other than the parent to come in and review or inspect a student's records, that should be a giant red flag to you. That's maybe it's, I didn't need to say that to you, but it should be telling you that something's not right and they're having a third party review the education records. It's usually the sign of an impending or current conflict. Don't see it very often, but when we do, it's that red flag moment. When there has been a request for records or access to records, FERPA gives us a deadline. So we have 45 days to provide access to education records. So sometimes, for example, you're in a dispute with a parent and you get that all-encompassing record request. I want all of my child's records, their CUME records, all their special education records, all of their disciplinary records, all of the correspondence about my student. It's a lot, right? We get those and they're long paragraphs. We have 45 days to respond to that. Remember that FERPA is a statute of access. And so often what I will do as a practical matter is not wait 45 days to produce all of that. Some of that I can produce right away, right? I can say to the parent, I'm happy to arrange a time for you to come in and review the CUME file and the special ed file. We can do that within the next 2 days, right? Give me a time that works for you. But we'll be having to do an email pull, for example, to get all of the correspondence. And when you do an email pull, you may pull thousands of records that need to be reviewed, potentially redacted because they reference others, or they don't actually reference the student if the student has a particularly common name. And so we'll be providing correspondence on a rolling basis to you. As long as you've complied within the full 45 days, you can do rolling productions to parents who have done those really large record requests. We, of course, would advise you to keep a record of on what dates you made what records and how many pages of records you made available so that you can show that you did that in the end. But it is a 45-day timeline. There is an exception for students with disabilities. If the student is a student with a disability and you have an impending IEP meeting, there is a provision of the operating standards that says parents have a right to access the records they've requested prior to the IEP meeting. So if you get one of those the night before the IEP meeting, that may be problematic. You may need to reschedule that IEP meeting so that you have time to comply, or have a conversation with the parent and see if they're willing to waive. That becomes more difficult when you're right up against the annual due date for an IEP, but just bear in mind that that exception exists, that they are to have access to the records that they've requested prior to any IEP meeting, due process hearing, or resolution session. The IDEA and FERPA also give a right to parents with disabilities that they are entitled to an explanation about the records. So if there are records, let's say in a special ed file or a psychologist's file, that may need some explanation, the parents are entitled to a reasonable explanation to that. And we have already talked about the inspection and access is different than copies. There is no provision of FERPA or the operating standards that requires we provide copies. It's we provide access. The exception to that we've already touched on is when the lack of providing copies would somehow interfere with the parent's right to participate. So again, think of that parent who is not physically able to come into the office, Maybe it's a parent that has a disabling condition and will need to be looking at records under a magnifier, that they only have at home, or they're not living in the area. Those may be situations where we would provide actual copies. Your board policies will talk about whether or not you can charge for those copies when you do provide them. So check those out when you are in those situations. Okay, so the last thing we've talked about, or that's on this screen, is record amendment. And so I want to talk about the right of parents to amend records. Both FERPA and the IDEA allow a parent to ask you to amend an education record. The reasons that they can ask to amend the record are limited. They can ask them when the parent believes that the record is inaccurate. So let's say your prior written notice has the wrong date. It says that people were there that weren't there. Okay, those are inaccuracies. A parent can ask you to correct for that. The parent believes that it is misleading. That's got some room for interpretation, or it's in violation of the student's right of privacy. And so those are the three reasons that we are required to amend a record. Now, I'm sure some of you out there in the special ed world have written a prior written notice, and you've had a parent say, I want you to change this prior written notice. It does not reflect what I think it should. We're going to talk about prior written notices as a procedural safeguard. That's a request for a record amendment, and there's a process for that. So both FERPA and the operating standards and your board policies all outline that when there is this request, the district has to go through a process. And the first part of that is the record inaccurate, misleading, or a violation of privacy, in which case we just fix it. But if not, then the parent, the district could say no, and the parent has the right to ask the district to go to hearing. And a hearing officer would hear this dispute and then ultimately decide whether or not the record could be amended. We have to notify parents if we're going to refuse to amend a record and tell them of their right to have this hearing. And then after the hearing, they either, you get some sort of ruling from the hearing officer, which says, yep, amend the record, district, or nope, you don't have to amend the record. It's accurate, it's not misleading, it's not a violation of the student's privacy. And at that point, both FERPA and the IDEA give the parent the ability to issue a statement of disagreement that will be attached to that education record and maintained with that record for the remainder of its, retention. So when I get a request to amend one of the prior written notices that we've belabored because we wanted it to accurately reflect what occurred at the meeting, and parent says, I want you to amend it, very frequently, one of the common practical responses is to say, we understand you don't agree. We believe it's accurate. You are welcome to submit a statement of disagreement, which will be maintained with the record. Sometimes that takes care of it, because the alternative is to say no, and here's your right to a hearing, and employ a hearing officer and go through the hearing and get to the same place. So when you get those might be worth chatting through with district's legal counsel on the best way to respond, but recognize that there is that right of parents or the eligible student to amend a record. Okay, so those were a lot of rights. What about the right to the obligations to retain and or destroy records? We had part of this question already in one of the questions from our audience members. We are required to retain records according to our record retention schedule. We can only destroy records in accordance with that same record retention schedule. There are many special education records that under that record retention schedule, when you take a look, says they will be permanently maintained. And I can vouch for this. I can remember when I was pregnant, I needed a record of, with my kid who's now 17, of some shots, and I could not find my shot records. And lo and behold, I did a record request for my medical records in high school and I got them. So, some things really are kept for forever. But it's all about your record retention schedule. Okay, we've talked about this next thing, I think, a little bit. I'm almost wrapping up to where you guys are gonna probably get a chance to go refill your coffee cups. How is FERPA enforced? We've talked about this. Some of FERPA, or education records, I should say. How do we enforce education records violations? Some of this, it depends on what law the parent is using. So, for example, if you have a special education parent who is claiming a confidentiality breach, they may use the operating standards, and that could be processed by the Ohio Department of Education. Although now I look at this slide and I realize that that needs to be updated because we don't have the Ohio Department of Education anymore. We have DO. Let's say, however, that the parent is solely under FERPA and they're not using the operating standards as the framework for their claim. Then we might be under the U.S. Department of Education and that Family Policy Compliance Office that we talked about earlier. So those are the different ways that these could be enforced. I think with that, I may be at the end of records and only 2 minutes over. So I think what I am going to do is say to you all, since I don't see any questions, why don't we take a 10-minute break to refill your coffee and take a bathroom break, and then we will come back and you will not be listening to me. You will be listening to Claire on other procedural safeguards that are available for students with disabilities.
Hey everybody, it's 10:14, so I hope you are back already. I've heard the recording notice start again. So I'm Claire Parsons again, and I'm going to talk to you right now about procedural safeguards. And I know that this session is probably a little bit on the drier side in terms of really digging deep into some of the regulations and the procedural requirements of FERPA and IDEA. And I wanted to sort of just break this up a little bit and help us remember why this is really important before I launch into a discussion of the regulations. And so I've got three things that you might want to just kind of consider and reflect on as you're listening, just to keep in mind. So one of the things about these procedures that we're going to go over is to remember that there are two components of FAPE under the IDEA. There is the substantive component to provide FAPE and adequate IEP and adequate services for a student. And then there's the procedural component. So we're talking about these procedures and they matter. And I acknowledge that not every procedural violation amounts to a denial of FAPE if you get into a due process scenario. But procedures are important in our legal system and under the IDEA. And I will also say that they are very important from the standpoint of psychological and emotional issues that do come up in these cases. They are a way to show the district's good faith, that not only are you going to do the right thing substantively for a student, but you're going to follow the rules and honor the rights of the student and the parents as you do so. So that's one thing to keep in mind as we're listening here. Another thing, just from a strategy standpoint, is, I have litigated a lot of these cases. And so these procedural compliance things, since we're in basketball season, I will say they're more the free throws and layups. You can win basketball games with free throws and layups. You certainly don't want to lose basketball games from free throws and layups. And another thing to remember is not only does procedural compliance buy credibility and help a relationship with a parent and a student, it also will be very important with hearing officers or judges if you ever get into the situation of litigation. So it's something to really just pay attention to. And like free throws and layups, procedural compliance comes from practice. So, as we're going through this, it's good to reflect on, what is my district policy as to this? Am I really clear on how we're doing this internally within the district? And also, you probably saw Melissa refer to her notes as she's presenting on records. I'm going to be referring to my outline as I'm presenting this stuff because you can't memorize it. So if there's one thing that law school taught me, it's that always check the rule. And so I think that's a really good piece of advice for dealing with any of these procedural things. Check the rule, consider how it applies here, go over it with your legal counsel. So with that, I'm going to get started with talking about surrogate parents first. So as most of us know, one of the hallmark principles of the IDEA is inclusion of parents. Parents have to have meaningful participation in the IEP process, and that is a bedrock principle of IDEA. But as many public school educators know, understanding who the parent is and who can count as a parent can sometimes be complicated. We've already had questions today reflecting that. And one of the more challenging situations you might be put in is identifying a surrogate parent for a student who does not have a person that qualifies as a parent under the regulations. As I've already alluded to, the definition of parent is broader than simply adoptive or biological parents. And so you should consider that a definition as you implement these things. But if you do need to appoint a surrogate, there is a process available. And this happens when no parent can be identified. The district has taken reasonable efforts to locate a parent and can't do so. The student is a ward of the state under Ohio law, or the child is an unaccompanied homeless youth as identified by McKinney-Vento or the No Child Left Behind Act. So when this happens, the school district of residence has the obligation to assign someone to act as a surrogate parent. So the obligation under the IDEA to include parents is so great and so strong that districts are simply not allowed to just proceed without a parent or just proceed without any involvement at all. You have the obligation to appoint a surrogate. So you may be wondering who a surrogate parent is or who can serve as a surrogate parent. So a surrogate parent is a trained individual who acts in place of the parent to make educational decisions on behalf of the children who may be eligible for special education or related services. So the district has some limitations on who they can appoint as a surrogate parent. This cannot be done, notably, when there is someone else who may fulfill the role. So we can't use the surrogate parent role to get around a difficult parent. That would be a problematic thing to do. This is only a situation where there truly is a need for it. For children who are wards of the state, the surrogate parent may also be appointed by a judge with jurisdiction over a matter. So you should know that in general, this is the obligation of the district of residence, but this is one situation under IDEA and Ohio implementing regulations where judges actually have some authority to make rulings directly that affect IDEA processes. So in terms of the timelines, like how quickly do we have to make this decision? So 30 days is a kind of standard reasonable time length of period of time in general, anything relating to the law. So that's the general time limit, the outside time limit for appointing a surrogate. But the real answer is as quickly as you possibly can. So we don't want delays in services or development of IEPs or anything like that for students for procedural things like this. So the more quickly you can make a decision and identify someone appropriate, the better off you are. The school district of residence, as I've said, is the entity that has the obligation to appoint a surrogate. In some situations, if there is, for instance, a placement to a school that is a distance away, the school district of attendance may actually take on the role of appointing a surrogate. And that would be because it might be that they are in a better position to identify someone to work with and serve the interest of the students and attend meetings if they are in person. And so it might just make more sense. But that is a case where, you know, both districts work together to agree on that. If there is no agreement, ultimately the district of residence still has that obligation. And I would just say that, you know, at that point, you know, consider these alternative meeting options that exist in terms of whether it's phone or Zoom or something, if you have to work through the procedural ramifications of that, because those options still exist even with a surrogate parent. So what does a surrogate parent do? So what a surrogate parent does, and I think the closest analogous situation to this kind of role that I've seen otherwise in the law is that surrogate parent is almost like a GAL, but for a student in the IDEA process. So they have the right, like other parents, to review records to make informed educational decisions. They have the right to provide consent to evaluations or for services. They have the right to agree or disagree with IEPs, ETRs, or any changes in placement. And they have the right to disagree or dispute the recommendations of the school district by using the procedural mechanisms available under the IDEA and Ohio law, which include mediation, a formal complaint, or requesting due process hearing. So this list is exhaustive though. So surrogate parents don't necessarily take on any other roles of parenthood because the IDEA doesn't really extend that far. Otherwise, those kind of parental rights are determined by other sources of law and other venues. So this is the full and complete list of what they do. But as to IDEA processes and IEP development and services, surrogate parents have pretty much the same rights as parents for educational decision-making purposes. So who can be selected as a surrogate parent is the next thing we need to consider. So first of all, the surrogate parent can't be an employee of the State Department of Education, the school district, or any other agency that is involved in the education or care of the child. And that might make it a little bit harder to identify someone, but the reason for that is we want to make sure that this person has a relatively impartial view of the situation and is really acting in the interest of the child. So to be subject to the Department of Education or the local district control could interfere with that. So that's the reason for that rule. The person also has to have no personal or professional interest that conflicts with the interest of the child. So they need to be acting in the interest of the child and not in their own interest or be influenced by some other thing. And that's similar to, as a lawyer, when I represent my client, I'm only representing my client and I'm not letting my, external business or other, interests affect that. I'm putting their interests first. And this is similar with a surrogate parent. And the surrogate parent also must have knowledge and skills to ensure adequate representation of the child. And to ensure that they had to have completed surrogate parent training, which is available online and can be done in a few hours. But it is important that they get that training to understand their obligations. So the operating standards also have some provisions relating to compensation for parents, potential liability of parents, the procedures relating to the judicial appointment of parents, surrogate parents that I mentioned, and the ability of children who have reached the age of majority to request a surrogate parents, and specific provisions that relate to the appointment of parents for unaccompanied homeless youth. So just be aware that what I've said here today is not necessarily everything, but as I started out at the beginning, when you get to situations involving surrogate parents that are anything other than run-of-the-mill, and this is my general standing advice for all procedural questions, if it's anything other than something you've dealt with before, you're 100% sure you're applying the rule correctly, check the rule, confer with legal counsel, consider everything in detail to make sure you're getting it right, because including the parent is essential under the IDEA. And so we want to make sure we get the right person involved when we have questions about this. So I don't see any questions, but we're going to move on now to parental consent. And parental consent kind of explains to us why getting the right parent involved really matters. Because parental consent is kind of embedded in IDEA processes all along the way. And so we really need to make sure we get the right people at the meetings, and the parents have full and adequate participation to ensure that consent is informed and that it's obtained and documented as we go through these processes. So one thing to kind of note here is we've got 4 things on the screen where consent comes up. So it's initial evaluation, reevaluation, services, and change of placement. And as I'm talking, it might sound a little like these don't make sense and these kind of conflict. And it gets a little bit confusing as you're listening to these consent things. So again, always look and check the rules if you have concerns about this. There is some difference between the initial evaluation and the reevaluation. And then there's a huge difference when it comes to services. So pay attention as we're going along. So for initial evaluation, the district has to obtain informed consent from the parent of the child before conducting the evaluation. So we have to be careful that we don't confuse the provision of consent for evaluation with the provision of consent for services. Those two things must be separately obtained in their own time. So we might get consent to evaluate, we might determine eligibility, and then the parent can choose to decline consent for services. And that's their right. So just getting consent for the evaluation is not the same as consent for services. We have to do it again every time we develop that IEP and offer services. For initial evaluations only, if a child is a ward of the state and is not residing with their parent, the district is not required to obtain informed consent from the parent for an initial evaluation to determine eligibility. If, and there's three things here that are required, if they've made reasonable efforts to do so and cannot discover the whereabouts of the parent, if the rights of the parents have been terminated in accordance with state law. And when you talk about termination of parental rights, that means there's an order somewhere. So just be aware that if there's not an order, it's not a termination situation. Parental rights are constitutional. And so parental rights have to be terminated by a court in order to, provide that. So if people think there's a termination, but they don't have an order, then you really need to check for that order. And then the next thing is that the rights of the parents to make educational decisions have been removed by a judge in accordance with state law, and consent for an initial evaluation has been given by an individual appointed by the judge to represent the child. So in some cases outside of termination, sometimes family court or juvenile court orders can restrict or remove educational decision-making authority from one of the parents. They may vest it in another parent, or they may vest it in another person, such as a guardian, otherwise to make those decisions. So again, looking at these orders can really matter. And I have just as a school attorney encountered many situations where parents might represent that there are certain orders and then they don't have them. And so it's really important to get the order and look at it when you're considering these kind of issues. Now, if the parent is of a child enrolled in the district or seeking to be enrolled does not provide consent for initial evaluation, the school district of residence may, but is not required to, pursue the initial evaluation of the child by pursuing mediation procedures or due process procedures. Now, this is not often used in my experience, but I do think there's one kind of tension, and I'm going to allude to this later, that the regulations kind of alleviate the obligation under child fine. They don't so much necessarily and directly alleviate the FAPE obligations. So when it's an initial evaluation, I feel like this situation might be a little bit easier because you may not know so much about the student and may not have served the student before. When we talk about like reevaluation and consent, this question might even get closer. So you don't have to pursue mediation or other kind of processes to try to resolve the conflict. I do think that there are, kind of ethical and maybe practical reasons why you might want to consider that. But it is something that this is definitely a judgment call situation where you have to consider the cost and benefits and potential risks. So this is a situation where if you're thinking about whether how you want to respond to the refusal to provide consent, you probably want to involve legal counsel at that point. But one thing to also remember is, when parents don't provide consent, you don't necessarily want to pressure them, but you could educate them about what that means. In many cases, parents sometimes don't know. And so I don't think it's necessarily problematic to just inform them of what that means. And then what next steps might be in place, like if they maybe should change their mind. Another thing I will say on the consent piece when it comes to some of these things is that I would be cautious and careful and look very carefully about the language used by parents that may potentially be, not providing consent. Obviously, if you've got good documentation procedures and you're confident that you've provided a form to them and everything has been explained and they have, declined to sign, that's one thing. I have sometimes seen correspondence between parents and school staff, where sometimes comments have been made and clients have sometimes called me to ask, does this mean they're refusing consent? And I think, like, I kind of tell them, we generally might want to go back and understand what it is they're saying. So just be cautious that you don't take one-off comments necessarily as a refusal of consent. Make sure you really understand what their intent is. So when we're talking about consent for services, this is the one that you really want to pay attention to. And note, this is separate from evaluation. This is after we've done the evaluation, you developed an IEP and made an offer of services. So a district of residence that is responsible for making FAPE available to a child with a disability must also obtain informed consent from the parent before the initial provision of special education and related services. So informed consent is really important. That means they've had some information about their right to refuse. They've been provided procedural safeguards in their notice at relevant meetings, and that I think that they have a good understanding of what the offer of services is. So we'll talk about prior written notice later at the end of the session, but just kind of bringing up the idea that that is very important because it can go to some of these fundamental things. So, so if a parent refuses consent for special education services, or the parent fails to respond to the request to provide such consent, the district is not permitted in this case to use procedures to obtain that agreement. This is the one where they're actually prohibited from doing so. And you will not be considered in violation of the requirement to make FAPE available to the student or your child find obligations. And you aren't required to convene an IEP meeting or develop an IEP. So when we're talking about the denial of consent for services, that's where the parents have put up a boundary and the district needs to honor it. Again, I think there can be discussion as part of the informed consent process about what this decision means. I don't think you should advise parents on what they should do, but I think you can answer questions about what it means and be clear about what they're saying. But once they have made it clear that they are denying consent for services, then that's when we have to respect it. Now, when it comes to the consent for a reevaluation, this can get a little bit more complicated. I think in part because we know more about the student. We have a better idea in general for working with students what the student might need. Now, sometimes we have a consent for a reevaluation that might come up for students who are new to us and maybe have not always been appropriately served at the prior district, especially if it's from a totally different state or it's been so different that it's hard for us to understand. But a lot of times this can come up with students that we are familiar with. So it can be a little bit more difficult because we have more of a track record. But even so, in the case of reevaluation, when it is a true reevaluation, we still do need informed consent. Now, if the parent refuses to consent for the reevaluation, the districts of residence may, but is not required to, pursue the reevaluation by using the consent override procedures. So in this case, the school district of residence, in theory, could pursue a due process case to have a hearing officer establish that the evaluation is reasonable and appropriate and can be done outside of the parent's consent. Now, I do not find that this procedure is used very often, in part because, generally school districts don't want to, incur litigation. They generally, want to avoid it. And it can sometimes be risky to do so. I have considered it very strongly at least once in one situation where a student really did need some services, and we were concerned about even being able to educate them without the evaluation and understanding their needs better. Fortunately, that was a situation where we were able to work with the parent to secure the consent and help them understand all their rights, including, for instance, independent educational evaluation, which we'll get to next. But it is not something that is often used, but that mechanism is there. So one thing to note in the regulation is that for this one, the regulations say that the district is absolved of the responsibility for child find. It doesn't really go into FAPE. And a denial of a request of services or consent for reevaluation is not necessarily the same as a denial of consent for services. So just remember to keep those things separate and to kind of look at these obligations, you know, kind of in a context. So parental consent does not need to be obtained, as in most cases, if we've made reasonable efforts to get it and we can't provide it. Now, one thing to remember that sometimes, one thing to consider if you are thinking, should we do a due process? Should we like pursue more means to try to get this consent? Is one thing to consider is whether you truly need it. You can do a records review and you can look at existing data and other information without consent. I mean, that's not something where you need more consent. So if you have existing evaluation data, like if you have a good idea of abilities and you don't necessarily think that there has been a true change since the last evaluation, you can review that data and review like other assessment materials that kind of come in. And you may be able to develop an IEP appropriately with what you have. And if you do, then I don't know that the reevaluation is truly necessary. So you may not think due process is essential there, but that's a time where you may not need to worry about the consent. So that, as Shannon just asked a question about if a parent does not respond to repeated attempts to obtain consent for reevaluation. So the regulations actually address this specifically. You can proceed if the parents have not responded, but let's remember, let's define repeated attempts, okay? The thing that I think the law and the guidance, you know, really shakes out to mean repeated attempts means at least 3 times, but at least 2 kinds of, you know, different mediums of communication. So there should be, you know, there should probably be an email, you know, there should be a phone. And I would just say, like, any way that we can contact the parent that we have available, if we have a home address, if we have a phone number, if we have email, you know, I'd say we try all of them. So make sure it's multiple documented attempts via different means, because as I've said, consent and parental involvement are so important. And then, like, I would also say, if later the parent, you know, decides to get involved again and show up, you know, it might be a good idea to kind of bring them in and have an IEP meeting and review things with them to kind of cover your bases and make sure, you know, they're brought back into the fold. So I've got another one. Shannon's hit me up with all kinds of questions. Thanks, Shannon. Can you conduct an updated or new assessment for reevaluation if you've made repeated attempts to obtain consent for evaluation and the parent has not responded? So I think when you're getting into, if you're getting into new assessments, that is truly probably the reevaluation mode and not review of existing data mode. And if you're doing new assessments that haven't been done before, then as long as it's truly a new evaluation kind of assessment and not like looking at new assessment data, like your STAR or your MAP or whatever testing you're using, that probably wouldn't be new evaluation territory. But when you're like doing a new kind of psychological assessment or doing a new you know, cognitive assessment, you're probably you're in reevaluation territory. And so that's when the consent provisions apply. But as I've said, the regulations say that when you have made multiple attempts to get consent from the parent, you know who the parent is, they're just not responding, you've documented that with multiple and varied communication attempts, then you can proceed.
I'm sorry, this is Leila Ba. Can you touch on that a little bit? Because I think I'm a school psych, part of our concerns are a lot of the evaluations were done during the pandemic. So we were evaluating kids through, tele-evaluation. And so I've heard that I understand what you're saying, but you just said a cognitive ability assessment. We do also do academic assessments as a part of our evaluations. Would that also fall into line as if you're not getting the parent consent, you also should not be doing an academic achievement assessment? Thank you.
Yeah, and I think like so. I think when you're talking, you said academic assessment. So I think if you are providing a separate test or assessment, like we're using the word assessment, and I think it gets confused because assessment comes up multiple times in the auspices of education. So if it's assessment data that we are taking in the classroom normally, for most students, that's something that would tend to suggest to me that that would be more in the realm of existing data, okay? Now, if you're talking about an additional assessment tool that is measuring and it's normed against other students based on age and grade and things like that, that's something that is more likely to be something that falls under the auspices of the evaluation tools. And so I think that when you're talking about those kind of things, and frankly, if a school psychologist is administering it, I mean, that's something that's telling me that's more likely to be an evaluation situation. So consent probably is going to be required if this is something new. But for any kind of evaluation that is conducted, the consent exceptions that if a parent does not respond to repeated attempts, those apply. So I hope that is answering your question. There isn't necessarily, so evaluations, what you have to look at is, are we gathering something additional to understand and to add data to what the committee is going to be considering for purposes of developing an IEP or offering services or determining eligibility. So it sounds to me like the assessment you're talking about probably is more of an evaluation thing versus just classroom-based assessment. Melissa, do you have anything to add?
Yeah, I would agree with everything Claire has said, but here's the way I look at it. And in these situations, always work with your counsel. But the regulations talk about consent, and there's a different provision for initial evaluation versus reevaluation. And the provision that allows us to go forward in the absence of parental response only exists in the reevaluation. And so you have to be really careful about how you look at reevaluation. If they're, if that Wyatt was never done before, right? I think there's a colorable argument that a parent could make that you need consent for that. If you've done the Wyatt for the first initial and you're doing the Wyatt in the reevaluation, I think you fall more squarely under that reevaluation exception that Claire is telling you about. So I think it's very specific, and you need to figure out where you want to take that risk. Just know that language is out there.
Okay, not seeing any new questions. So let's talk about change of placement. So IDEA actually doesn't require consent for change of placement, but IDEA has lots of little places where state law can inform the requirements, the national requirements under federal IDEA. And Ohio has opted to do that. So when it comes to a change of placement, and that is defined as a change from one option of the continuum of alternative placements to another, which is a judgment call situation in some cases. Obviously, if you're moving a child from one place on the least restrictive environment spectrum to another, you're probably looking at change of placement. If you're making a significant change in services, that could be a change of placement. But This is definitely a judgment call situation. So this is one to look closely at what's being changed and involve legal counsel. But if that happens, informed consent is needed from the parents. Now, now there are some exceptions to this one as well. A change in placement is not required if the district can demonstrate that it made reasonable efforts to obtain consent and the child's parent failed to respond. As I said before, multiple and varied attempts at communication and seeking this consent. A change in placement is not required if it is the result of a disciplinary action. Now that's, make sure that when we're considering that, this disciplinary action has been done in accordance with district policy and IDEA requirements as to discipline. It's also not required to review existing data as part of an evaluation or reevaluation, or to administer a screening test or other evaluation that is administered to all students. But when we're talking about a change of placement, that is a time when we need that informed consent in general, unless one of the exceptions applies. Now, let's talk about revocation of consent. So if parents have the right in certain circumstances to give consent, then they must have the right also to take it away at any time. So what happens if they do that? They provide consent to evaluation, or they provide, really this more comes up with services, unless we're in the midst of an evaluation process. But if they give us consent to provide special education in August, and then come January, they change their mind and revoke consent, what do we do? In situations like that, the district has to stop providing special education services, and they have to provide prior written notice before ceasing the services to the parent. And that's to make sure, and we'll talk about prior written notice very soon, but that is in part to make sure that they understand what the actions that what their revocation means, and what it means for the student going forward. In a revocation of consent situation, and this is revocation of consent for special education services, the district cannot use mediation or due process procedures to obtain the agreement. This is they put up the boundary and we have to honor it kind of situation. We also will not be considered to be in violation of the requirement to make FAPE available to the student, or provide other special education services. And we are not required to convene an IEP meeting or develop an IEP for the student. But just kind of raise your consciousness to this, and we'll talk about prior written notice next. If it's a situation where consent has been revoked, and sometimes there can be varying ways of doing that, that's one reason that the prior written notice might be really essential if no IEP team is convened after that point, because it will document our compliance with the situation, and that we've given the appropriate notice in light of the revocation. And just as kind of another reminder, when we're talking about parental consent, it's not required to review existing data. It is also not required to administer a test or evaluation that we administer to all children. That's the consent proceedings, procedures don't apply that far. We're talking about specific evaluation or other procedures under the IDEA. Now let's talk about independent educational evaluations. These come up a fair amount. So this is usually what happens is we're kind of moving away from consent now, because with independent educational evaluations, these happen when we've gotten consent to evaluate or had an exception or something like that. We've done an evaluation and the parents disagree, usually. So independent educational evaluations are conducted by a qualified examiner who's not employed by the district, and they can be secured in a couple of different ways. So the parents of a child with a disability have the right to obtain one independent educational evaluation at public expense each time the district conducts an evaluation. So parents may get an evaluation, they may disagree with it, or want further information. And so they may request of the district to have an outside person conduct further evaluations. And IDEA gives parents the right to do this and to have the district pay for it, but there are some limitations on this. So one limitation is that the examiner has to satisfy the district's criteria for applicable independent evaluations. So usually, and one thing I will say about the criteria piece is that I still encounter districts that do not have any written criteria. So if you do not have those, it can be somewhat complicated to tell parents that their evaluator of choice isn't acceptable, because they, if you don't have them in writing, that doesn't necessarily look like it's the most credible. So I do recommend having some criteria. You have to be careful in drafting those that they're not too restrictive. But like you can include some limitations in terms of expertise and things like that. Generally though, when there is a parent request for an independent evaluation, my recommendation is usually to honor it and to just get it set up and move forward with it to try to not cause extra delay. But you may be able to talk to the parent about the scope of what's evaluated, who's going to do it, and you may be able to impose some reasonable limitations on expense, but be cautious with that, because if it is so restrictive that essentially it means no evaluation is going to happen, you're impeding their rights available under the IDEA and the operating standards, and you want to be cautious about that. So now, if the parent disagrees with the evaluation, they're entitled to the independent evaluation. Note that they don't necessarily have to tell you what they disagree with or why they want this evaluation to get it. You can ask for informational purposes, but they really don't have an obligation to tell you. So you can't hold up an independent evaluation because the parents won't tell you why they want it. So now, if the parent requests an independent evaluation, there are two options for district. And to be honest, they're not great options. One is to just provide the evaluation, and another is to file for due process. And I've not really seen the due process option exercised. Sometimes there are concerns that districts have about the particular nature of the evaluation request, whether what the parent is asking is truly an independent evaluation, because, for instance, there may not have actually been an evaluation within that they're really contesting. It may be that they are, concerned about like an observation and they want a full-scale psychological assessment because they don't agree with the observation. So we've had some issues where we've kind of worked through those things. But in general, it just makes more sense to, to honor the request versus filing for due process. If you do file for due process, the scope of that hearing should be narrow. But the problem, I think, always remains, and the doubt that I've always had in my mind as a litigator is, if you do choose to file for due process to try to just establish the reasonableness of your evaluation, which should be narrow and short and not as expensive, does it trigger the parent to file a due process of their own or to try to raise other things in the hearing? And will hearing officers really be able to manage all that? So usually the due process mechanism isn't used, but it's there to just be aware of in a strange situation where it might be a better alternative to providing the evaluation. And then once you have actually decided on who the evaluator is going to be. You've set it up. They've done the evaluation. Once this happens, the parent then actually has the right to have that evaluation considered by the district. And that is something that should be documented and considered in good faith. So outside of this situation with independent evaluations, what does happen commonly in my experience is that parents also will go obtain additional evaluations or provide additional input from outside providers who may be people that would be otherwise qualified to offer evaluation data. And when they do that, it's not something where they can necessarily retroactively seek reimbursement for that evaluation. I have had parents attempt to do that, and they don't really have a right to that, depending on the circumstances. But they do have the right to have those outside evaluations considered, okay? So that means, reviewing the information, discussing how it may relate to the student services or eligibility or whatever issue is coming up. And then you want to document that too. I have had it come up in due process hearings that parents allege that due consideration of outside input was not given. So this is something to document in, as we'll talk about in a bit, in the prior written notice perhaps, or, in your notes from the meeting. So one little thing about district criteria that I missed while I was talking about independent evaluations, if the independent evaluation is at public expense, the criteria under which the evaluation is obtained, including the location of the evaluation and the qualifications of the examiner, must be the same as the criteria that the district of residence uses when it initiates an evaluation. So you can set some criteria, you can establish some basic limits, but the limits need to be really about ensuring that the data that we're paying for really is relevant, useful, credible, and things that we can actually consider in the process. So I don't see any questions at this point, so I think it's time to move on to prior written notice. So I'm going to turn it back to Melissa. Oh.
You got one right there under the wire, Claire.
Okay, so Kamala asks, I think, and I'm not exactly sure exactly what you mean by this, but Kamala is asking, does the school district have the right to see the IEE before the school teams meet with the family to discuss? I don't think the regulations are that specific. I think ideally you would, what I would generally say is, if you get a request like in a meeting or via email for an IEE, you set it up. And then once that evaluation comes in, then you set another meeting to discuss it, as long as this works with timelines and things. So I would say, like, if you can manage this from a just administrative standpoint of let's have this in hand before we set the next meeting, you might be able to avoid that. But like, I don't know that you have truly a right to it. But I would say, like, manage it more from avoiding the fight. But you can, if like you have a meeting set up and the parents show up with the evaluation, depending on if you have timeline issues or whatever, an option might be to, can you give us a half an hour or an hour to study this and then we'll come back? Or can we take some time to study this evaluation? It's important to us to make sure we understand this thoroughly. And then can we set a new time to meet? So I think, like, what I would say is you don't necessarily have a true right. You need it as a practical matter to be able to consider it. So I would think more like, how can we avoid big problems, but make sure we're doing our job to consider it? And that's the way I would address it. I don't know if Melissa has thoughts.
Nope, I would do the same. I would do
All
the
right.
same. All right, so we've left ourselves about a half hour to cover the last procedural safeguard. And some of you may be thinking, really, we're going to talk about this for a half hour? But yes, we are, because I can't speak for Claire, but I can speak for myself, and she can pipe in if she agrees. Prior written notice is my absolute favorite document in special ed. I know that it is often viewed by our special educators as just another piece of paper, another requirement. But hopefully by the time I'm done, my giddiness over, prior written notice will have rubbed off on you. Because I truly believe that a well-written prior written notice is a chance to celebrate all the things that we do, or you do, I should say, as educators. The reason you became educators. We of course see it as a procedural safeguard, and its importance, I hope you by the time we're done will agree with me, can't be overstated. But it is a document that we get to include everything we've done for a child, and that why we're doing. And a lot of times we don't get that ability to really share what we do, why we do it, how we do it, in a way that really reflects all the hard work that has happened behind the scenes. So a couple of things before we kind of jump in, and this section is a little bit more hopefully less dry. We are going to walk you through a hypothetical prior written notice, and we're going to give you another hypothetical where you can think about what you would write in the prior written notice. And at the very end, so this is the requirement that you stick around, we're going to give you a key to that hypothetical prior written notice, so that you can see what we're talking about. So when is prior written notice required? Well, you will recall that we used to, in Ohio, if at the end of that IEP, everybody agreed, parents signed as the as being in agreement with the IEP, let's implement, we didn't have to write a prior written notice, which is, I think, one of the reasons that special educators don't really like prior written notice right now. They're like, I didn't used to have to do this. But you will recall, or may recall, that right around Christmas, the former Ohio Department of Education several years ago gave you guys a gift that said, yeah, the IEP can no longer stand as prior written notice when the parents agree. You got to write it. So when do you have to do prior written notice? Anytime the district, and these are important verbs for the next half hour, proposes or refuses to do something related to the child, whether it's initiate or change the identification, to change or initiate certain services or programming. We're going to do an evaluation, the type of services, anything that relates to the provision of FAPE to a child. So we kind of joke, if you sneeze, write a prior written notice. But it is all the things that we're proposing or refusing. And then there are a couple of others when we have a child that's referred to evaluation, and when there is a disciplinary change in placement. Those are specific times that we are going to be writing a prior written notice. So again, prior written notices get written quite a bit. What doesn't require prior written notice? So maybe we agree that without holding an IEP meeting, that we do not need to go to a reevaluation. Don't have to write a prior written notice for that. Claire mentioned that we often do screenings, something that we administer to everyone in a classroom. That might be our STAR assessments or those kinds of things. We don't have to do a prior written notice when we're doing those types of screenings or IAT determinations, intervention assistant team determinations. When we release information, not a requirement that we actually issue prior written notice. We're not required to do it before we destroy that. If we do it in accordance with our records retention schedule, again, doesn't require prior written notice. And weirdly, when we're transferring rights when the student turns 18. I've never ever done a transfer of rights where it didn't get reflected in a prior written notice, but you know what? It doesn't have to be, apparently, under the rules of the regs. So what's our timing for prior written notice? Well, the word itself tells us that it's prior to something, right? So it must be given within a reasonable amount of time, which no one has defined, before the agency, you all, the district, propose or refuse to do something. So before you implement those changes in an IEP, you will need to issue the prior written notice. The old timers in the room, I don't know, I have to find a way to sit, more experienced individuals in the room, I'm trying to do this in a way that is not age related, will remember that for a while we had a guidance document from ODE that talked about different pieces and parts of the operating standards. Well, there are pack rats in our office who, of course, downloaded all of that commentary and guidance and keep it because sometimes it's helpful. And one of the things that ODE shared with us at the time was a reasonable amount of time was 2 weeks. So take that for what it's worth. That is not in the regulations, but that was in former guidance from the department. I think 2 weeks is a pretty long time to write a prior written notice. It's particularly going to be long if you're doing an annual IEP very close to the deadline and you have to implement a new IEP. You may not be able to take those 2 weeks, but there is this notion that you can have some time to write an appropriate prior written notice, not required the day of the meeting, right? So keep that in mind on the timing issue. There are specific timing rules on the issuance of prior written notice. When there is a referral for evaluation, there's a specific provision of the operating standards that says that we will provide prior written notice within 30 days of the date of the referral, whether we're going to refer or not refer. And there is a requirement on the disciplinary change in placement that those occur prior to the actual movement on the continuum. So if we're changing the placement to an interim alternative educational setting as a result of a legitimate disciplinary change in placement, we do have to issue prior written notice there. So what are the required components of a prior written notice? And we still have these forms. I keep hearing that they're going to be revised, but for right now, this is what the prior written notice looks like from due. So let's pretend as we kind of fill in the parts of the prior written notice that we have the following scenario. You are at an IEP meeting and the parents, Mr. and Mrs. Brown, surprise you with a request to replace their son, Charlie, a socially awkward little boy with a diagnosis of autism, at the Daisy Hill private day school. Daisy Hill leads the nation in research related to the therapeutic effects of beagle puppies in the classroom. The IEP discusses the request from the parents, considers the data, the IEP team, that is, and then the educators on the IEP team decide that Charlie's LRE should remain his current public school setting. So with that in mind, let's kind of think about what this prior written notice would look like. So the first thing we have is that box, what we call box number 2, the description of the action proposed or refused by the school district. There are those verbs again, proposed or refused. So I will tell you that, we are frequently asked to review a prior written notice after we are invited to an IEP team. I don't know about Claire, but I can tell you I never get invited to the IEP teams where everybody's in agreement. I don't know why, but I always seem to be invited to the problematic ones. But when I'm asked to review those prior written notices, I look for the verbs the district proposes or the district refuses. I even take the old school red pen and look for that, right? So, because I want to make sure that we're doing what we need to do here. So what would the example here look like? The IEP team met to discuss the parents' request to change Charlie's placement. After considering the request, the district is refusing to place Charlie at the Daisy Hill private day school at district expense. Okay, so district is refusing the placement, right? So that's an example of what that might look like. This is not a box, as much as I love telling our story, this is not a box where I put the minutes of a meeting. Frequently, I will have a number system. So 2A, district proposes, uh, additional services. District proposes to reduce minutes of service. District proposes, and they're A, B, C, and D. And then in 3, I correlate that. That's one of the things I do. But it is not we started and we met at 10:15. We talked about the students' progress. It's not a blow by blow minutes of a meeting. Claire, do you have thoughts on that?
Yeah, I mean, I have thoughts that this is going to be like Exhibit A in a due process hearing. This is going to be something that you would be cross-examined on. So if you do get into due process, what typically happens is a parent's attorney will go through all of the documents to try to kind of undermine the decision, or say that some outside influence came into it, or say that it wasn't really based on data. So think about this as this. So what you are doing sometimes in IEP meetings is generating a record that will be later reviewed by a hearing officer. So this is a summary of the record. It is an important document from an informed consent standpoint, but it is also an important document as an exhibit to a hearing. And it should essentially state your rationale for what you did and why you did it in summary fashion. And there is sometimes an art and a science a little bit to articulating that in a way where you say enough, but not too much. But it is important to, think about this document in that way.
Well, and I think that I also use the form to help me tell the story. So again, this is number 2, the action proposed or refused. So then we move to number 3, and that's the why. Why are you proposing or refusing a certain action? And so when I have my little red pen and I am either revising or I'm looking for certain terms, I really am looking for the because. So for example, the IEP team is refusing to place Charlie at the Daisy Hill Private Day School because the district can continue to provide Charlie with a free and appropriate public education at his current placement in the district, where he has made progress, as documented by the data reviewed at the recent IEP team meeting. Remember, I told you this is a document where you get to celebrate what you do, and particularly that you've done it well, right? In this case, this is a kiddo that's in your program, you're progress monitoring him, you've provided him supports and services, and the data shows that he's making progress. So put it out there. This is why we don't think he needs that change in placement. This is the because. And if there's more than one reason for why you're doing what you're doing, then this is more than a sentence. So you'll see the district is also refusing to change the placement because the Daisy Hill Private Day School would not offer Charlie the opportunity for interaction with his non-disabled peers. So we're going from a placement where he's presumably in a district building and has access to gen ed peers to a separate facility. That's a move on the continuum that would be more restrictive. And we don't have evidence that he needs it if he's making progress. Since Charlie benefits from peer modeling and socialization, and since his IEP addresses communication and socialization with non-disabled peers, the district members of the team did not believe the requested placement was appropriate or would constitute Charlie's LRE. So again, this is the because, and there may be more than one reason, but you're telling your story. This is where you, as the educators, get to celebrate the work you've done and your expertise. One thing that you may want to take a look at in section 3, you will notice that in that final sentence, we said the district members of the IEP team did not believe this requested placement was appropriate. Notice it doesn't say the IEP team believes that this was not appropriate, because in that litigation stance, as Claire said, this is document A. If you are defending your actions later in due process, the cross-examination of the special ed director or IS that wrote the prior written notice says something like this. So the IEP team decided that this was not an appropriate placement? Yes. Well, is the parent a member of the IEP team? Yes. Did the parent agree with that? No. So all of a sudden, your prior written notice is not accurate. When you are documenting disagreement, it is a term or a skill to be able to write those sentences that reflect the educators on the team or the district, and make clear that you are documenting an area of disagreement. The parent is a member of the team, so using the IEP team can backfire on you in those situations where there is some disagreement. All right, so going to number 4, a description of other options that the IEP team considered and the reasons why those options were rejected. So the example we have here is the district considered your request for placement at the Daisy Hill Private Day School. The reasons for rejecting that placement are stated above. The district is also considered placing Charlie in the district STAC program. So maybe we have a self-contained autism unit that would be similar to the or somewhere in between on the continuum between where he is and the Daisy Hill Puppy Farm. The district rejected that option because it would not be Charlie's LRE. The district members of the team continue to believe that his current placement in the regular education classroom with supports and services is the appropriate LRE for him. So again, what else did we consider? Then the next section is everything we considered and why, or everything we considered for the reason, that the basis for that decision. This is often overlooked. But this is where we're going to record, that we looked at the data, the progress monitoring, the progress reports, the ETR, the IEP. If we were having a true conversation with the parent, then it's going to reflect that we considered the information provided by the parent. If the parent brought in an independent evaluation or a recommendation, it's going to reflect that the team reflected on that as well. So those kinds of pieces of information you'll see in the example, we list all of that information, all of that possible information that could have been considered. So I had a question. The prior written notice document says a description of other options the IEP team considered. If that's not an IEP team, what if it's a parent conference and the team agreed to implement a 504 instead of testing for an IEP? We are still using the prior written notice to write it, but it's not technically an IEP team. I would just reflect that in the prior written notice, that the members of the 504 evaluation, team or whatever. I mean, I think, again, this is an opportunity for you to tell your story and what you're doing. But it is good to pay attention to those types of terms. Okay, finally, section 6. My favorite section. This is a description of other factors that are relevant. And this is because this is where some of those minutes, not all of those minutes, but some of those things that you guys love to take minutes on and throw into a prior written notice should go. Some of it's relevant. Things that I always include self-serving statements. So if the parents came in and said something like, oh my gosh, we love Charlie's teacher, he has blossomed under her, he has made so much progress, I am furiously writing down quotations because that is relevant information that supports why we didn't make the change, right? If the parent says, I think Charlie's making progress here, but this would be best for him. That's not our standard under the IDEA, right? Our standard is we've got to design a program where a student is that is reasonably calculated to allow a student to make educational progress. That's our obligation. That's what our use of federal funds is for. We are, many people that have been around a while will recognize this quote. We are required for providing the Chevy, not the Cadillac, or now the Tesla, right? And so we are, if that's what's driving the parents' request, I want to document that here in section 6. So for an example, other factors that were relevant to the district's decision include Charlie's progress during the past school year, as the district's desire to see that progress continue, and also relevant were statements made by Charlie's parents who were complimentary of staff who work with Charlie and the services provided. Although they explained that they were pleased with Charlie's progress in the current program. They requested the change in order to maximize his potential provided through the Beagle therapy in that program. Other things I would put in here is, again, let's say the parent didn't give you an IEE in advance and you needed to take time. You might say that that the parents presented you with an independent evaluation and the team took a break to review it for 20 minutes, an hour, and returned to consider it. It would be reflected here. It would also be reflected in 5 as the information that you considered. But again, this is a chance to show you did it right. You know what you're doing, right? And so I'm going to ask that you spend some time reflecting on that, because a lot of times I'll see an NA in this box and my skin crawls and I think, oh, we missed an opportunity, because we're sure that something there happened that we probably want to document just in case in the future we're defending this action. Moving through the rest of the form, we have the sources of parents to obtain assistance in understanding their rights. Please notice that prior written notices are required to be provided in a language that's understandable to the parent. So if you have a parent that is not a native English speaker, you may be responsible for getting the prior written notice transcribed into their native language. Again, it's a procedural safeguards notice, and we need to make sure that our parents understand what we're sharing with them. It's telling them why we're doing what we're doing. And so that is an important piece here. Overall, this document should be used to show the district's evidence of compliance with the IDEA, which is why, as a lawyer, it's my favorite form. It is the one that I celebrate and, want to see you guys, tell your story on. So we'll go through some really quick tips on how to write prior written notices before I do a crash course on our scenario. So top 10 handy strategies for drafting prior written notices. Assign someone to take accurate and detailed notes at the IEP team meeting. I know many ISs or district reps try to do both. It is very hard to facilitate a meeting and take detailed notes that can go into the prior written notice. I get to live in the little ivory tower of the law world where I can say, let's bring in an extra person to help you take detailed notes. But it really is important because someone's got to be listening to the asks, the requests that we're either going to accept or refuse. And then listening to the conversation around all of that and taking down why we either do or don't do what we do. Again, it's hard to both facilitate and take notes at that meeting. So sometimes asking a non-IEP team member to take notes is an option. Sometimes it can be a building secretary. Maybe it's the gen ed teacher who is, not being involved in all of the discussion of the SDI and the progress monitoring quite as much. But think about that when you're going into an IEP team meeting. Prior written notice is the documentation of your ultimate determination. It's the district's determination. So ultimately, unlike an IEP that is built by consensus, this is documentation of your determinations. And so it is a little bit one-sided. So you can understand why sometimes you get a parent that says, I need you to rewrite this. It's not their document. It's your document. It's your story. It's your reasons. Try to avoid leaving blanks on your prior written notice or using NAs. We already talked about that. You're missing an opportunity to talk about your compliance, about the work you're doing, about why what you're doing is working. Ensure that it's written in a language that's understandable to the parent. We talked about potentially having to translate that, but that also means not speaking legalese or special ed-ese. We as special educators, people who are immersed in this work all the time, speak our own language. Let me give you an example of what I would not want to see in a prior written notice. The IAT proposed a referral after the district provided RTI through an HQT and a para. The district considered ED due to ODD, CD, LD, and OHI, all due to the student's ADHD. The district found no eligibility under the IDEA, but insisted to the parent that there was a need for an IEP for FAPE and the LRE. The district also considered the parent's IEE, the district's FBA and BIP, the data collected after our PD at the SST on PBIS, and the district evaluated under eligibility under the 504 and looked at guidelines from DOE, OCR, DO, and the training materials from ESC. Now, you special educators know exactly what I just said, but I assure you that a parent would be like, huh? What are you doing? What are you saying? So again, take the time to make this understandable to the parent. Don't complete your prior written notice at the meeting. I know that that's very tempting, but again, I think these are important documents. You want to make sure that you're clicking all those boxes about your compliance. Monitor your timelines so that you are hopefully giving yourself at least a day to write that prior written notice. Seek assistance if you need it, of course. Your district's legal counsel are happy to help with these kinds of things. Know what to do when your parent disagrees with the prior written notice. We talked about that record amendment piece earlier in our time together today. Know how to prepare a prior written notice for when that special circumstance where the parent revokes consent. There are a number of very special, or I should say not special, specific provisions that need to go into a prior written notice when a parent revokes consent for special education. And those are listed in your materials on page 29, but it's got to be a summary of what the child needs, what they won't receive once they revoke consent, a statement that the student won't get any of the rights or protections under the IDEA. Parent has to understand what they are waiving. The next tip, what do I missed? So that's 8. We did that one. 9 and 10 is the last one, is when in doubt, as I said, when someone sneezes, prepare a prior written notice. So I crash coursed through that. I'm happy to work through for anyone who wants to stay on our scenario. I can probably do that pretty quickly, but I also want to be respectful of people's time. And so for those of you who need to hop off, you certainly may. We are very glad that you were with us today. I will take a minute to look at the questions. And again, if anyone needs to hop off, I'm not at all offended. So that first comment is from Kim. And then, oh, of course, I can't read this one. If we absolutely cannot get a non-IEP team member to attend and take notes, do we recommend an audio recording of the meeting that can later be reviewed? So, Joy, that's a really good question, and much of that's going to depend on your board policy. Some board policies prohibit the recording of IEP team meetings. Some are silent on that. I wouldn't record and not tell the parents, but keep in mind, if you have made a recording of the IEP team, you have created an education record that then must be maintained like all other education records. So just be aware of what you're doing there. Okay. So let's spend a few minutes on our scenario. You should have the scenario, and I believe Kim indicated that you will get the key for the prior written notice on this, just a little bit of extra practice on writing prior written notices. But here's what our prior written notice relates to. Gerald is a 4th grade student who has been receiving assistance in reading in the resource room under an IEP for the past 6 months. Recently, Gerald's been speaking out of turn in class to the point that other children are refusing to sit near him. Gerald's teacher has been sending notes home to Gerald's mother when Gerald is required to stay in from recess due to his behavior, and Gerald's mother is starting to get very worried about the increasing frequency of the discipline. Gerald's teacher is concerned that holding him in from recess may actually be making things worse, as now he's getting one-on-one attention from the teacher when everyone else is outside. Mom called Gerald's teacher one day to express her concerns, and Gerald overheard them discussing a plan for the teacher to try to ignore his outburst in class as to not reward his behavior. The next day, when Gerald's teacher ignored him, speaking out of turn, he smacked her hard on the back with a ruler. Gerald was suspended for a day, and Mom sent an email sent an email to Gerald's teacher requesting a conference, just as Gerald's teacher happened to be picking up the phone to suggest an IEP team meeting to address the evolving behavior. At the IEP team meeting, Mom requested a one-on-one be provided to Gerald with constant behavioral cues to keep him in line with classroom expectations and ensure he did not harm anyone. The educators on the team, however, suspected that Gerald's behavior was for the purpose of getting attention, and so they proposed conducting an FBA. Mom continued to insist on the aid in addition to the FBA, but the educators on the team were uncomfortable with this because it would provide Gerald with the additional attention that he was seeking and could further affect the data. Additionally, they didn't want to single him out in the classroom and socially isolate him further. Mom consented to the FBA, but continued to disagree on the provision of an aid. At the end of the meeting, Mom raised an additional concern. She'd been researching online and read about a special reading methodology that she thought would really jumpstart Gerald's reading progress. She wanted the methodology included on the IEP. Gerald's special education teacher shared that his current data, which showed he was actually progressing faster than expected under the current small group setting. And after the team reviewed the data, Mom agreed with the proposed reading methodology was unnecessary. In fact, the team agreed that based on Gerald's progress, they would amend the ID to reduce his time spent in the resource room by 10 minutes a day. This change would also give Gerald more time in his classroom before lunch, which would hopefully make that transition easier on him. Mom signed the IEP to consent to this change. In the end, despite somewhat heated disagreement about the aid, Mom appeared to be happy with the outcome of the IEP team and made a comment afterwards that she felt like her concerns had really been heard. That's a lot. Let's talk about what that prior written notice might look like. So let's start at the beginning. What boxes would you check? So the first thing I would say is when we are looking at that form, we actually are looking at a potential change in placement. Why? Because we're taking the minutes that he was in the resource room for SDI, and we are reducing them, thereby increasing his exposure to general education peers. So in some cases, I would argue that's a change in placement. For those of you that remember ODE's guidance that I referenced to you that we can no longer get our hands on, ODE would have said that wasn't a change in placement, right? Because resource room to resource room is all the same place on the continuum, and the number of minutes wouldn't be. As a lawyer, I can tell you I've played that both ways. So whether you check the change in placement box or not would depend on whether or not you had consent. And in this scenario, we had Mom okay with it in the end, signing consent. So I think you probably could check that box. We are, again, proposing to potentially change the placement. We are proposing to change, or we are refusing to change the FAPE. Mom's asked us to add a one-on-one, and we're saying no. So that's going to be part of our refusal. So that's going to be one of those other boxes checked at the top. And we would also probably be checking the box that says IEP team meeting where the parents and the district are in disagreement, because again, we've got that aid situation. All of those would be reflected in the then those proposals and refusals we just talked about. In the key, you'll see in the paragraph of the description in 2 of what we are proposing or refusing. So that reads, and you guys have it, but we address, we're proposing to conduct an FBA. So one of the boxes I missed was checking the evaluation, because we're proposing an evaluation. To gather data on his behavioral issues, the refusal to provide the aid, that's the services. We are proposing to change his placement. We are proposing to reconvene the team. So when you look at that key, look at all the places you see a proposal or a refusal, just in that short number 2. And again, just a model, but an idea of how we might put that together. The explanation of why, if you read through there, reflects what was happening in our scenario, but you'll see a number of the word because. And again, you see that we are using our prior written notice to tell our story because he's making progress. I get that we have given you now 2 scenarios where the child is progressing, and that's not always the case, but we were making it easy for ourselves. You, of course, can come up with other reasons for why you're doing something besides, let's say, progress. You will notice that when we talked about other things we considered, but was not doing the FBA and why we didn't, and that we considered providing him with a one-on-one, but why we didn't, it would increase the attention-seeking behavior that we are currently surmising might be the reason for part of his outburst, and that it would skew the data. And then you'll see what we've put under what we are using to make our decisions. Information about provided by Gerald's mother regarding that reading methodology is where we're documenting the parents' input and participation in this process. As Claire said, a cornerstone. Anything that the parent shares with you as part of that cornerstone of parent participation, we want it reflected. Very frequently, that's section 5. Sometimes that's section 6 of the prior written notice. And you'll see in section 6, we did, of course, put some self-serving language, as I said in there. Gerald's mother thanked the educators on the team for considering her concerns. And we also put that we plan on reconvening. We aren't drawing any lines in the sand. We're not telling her that we're not going to come back to the table. We are documenting right then and there that we are going to come back and reconsider that aid, hopefully staving off a litigation stance, because we're saying, look, we're going to collect data and come back. Claire, I know I flew through that. I know we're over. Do you have anything I missed that you want to share with our attendees that are still with us on prior written notice?
The only thing is like just a broader context of why this is important. And one thing to remember is the statute of limitations is 2 years, and it can actually be longer depending on if some exceptions kind of apply. So when you think about the fact that many things might happen, memories can lapse, it's just really essential to have these records well done that kind of verify what we're doing. And the other thing is when you're explaining the parent input and the rationale and all that, that can also be helpful for ensuring, staving off those predetermination or other kind of arguments that can come up if the action is challenged. So it's just really important to have your documents in line. It's an essential thing, and it's expected if you're any kind of government entity. So just do it.
Thank you, everyone, for your time today. Thank you for sticking around. Hopefully you love prior written notice now. I know I'm delusional, but I can always wish, right, that you guys will treat it maybe just a little bit differently now because it is my favorite document. And again, thank you, everyone. Have a great weekend, and hopefully we get to enjoy a little bit more of this sunshine.